Hi there, this is Kaushik Ranchod. Welcome to our immigration show. Today what we're going to be talking about, we're continuing our J1 hardship series and exceptional hardship, how that can be proved. We're going to show you some examples, one for a physician from India where we got a case approved, one from an Egyptian national. So stay tuned, smash that like button, and let's dive into it. So first of all, let's talk about whether or not you even may qualify. So in order to qualify, you need to have a qualifying relative, U.S. citizen spouse or child, or lawful permanent resident spouse or child. Having a parent does not count. Although the parent doesn't count as a qualifying relative, that could be a factor for hardship that could be discussed in the application. So, for instance, if you have your U.S. citizen parents are here, you're taking care of them, and then you'd be separated from them if you had to move to your spouse's home country, we like to include that argument as part of the hardship waiver application. Even though they're not legally a qualifying relative, it does add to the context of your specific situation, which builds hardship. All right, my friends, I love doing this work because it's about unification, unifying families. My father just recently passed away, and so it makes my work even more meaningful because unifying families, being part of your family, so important. Now, let's dive into it here. We're going to talk about the J1 hardship waiver for physicians. We're going to talk about that exceptional hardship for physicians. And in this situation, the physician was from India. So here, we're going to call this person Dr. Doe. Dr. Doe's spouse was also in residency. Now, they had a U.S. citizen child. We based the hardship waiver argument primarily off of the issues that could be caused with childcare, because physicians are very busy, as you may know. So they had to split off taking childcare, and if they had to go to India, where the physician was from, this would not be possible, or it would cause a huge increase in childcare expenses. Another issue here that we discussed was the fact that there were no other family members nearby that could help with the childcare, because USCIS could come back and say, well, what about other family members? What about the grandparents? Well, that's why we included that argument here. Now, in this situation, we received a request for evidence. Many of the times with the J1 waivers, it seems like there's no rhyme or reason, but every few months, they'll issue a spew of requests for evidence. There doesn't seem to be any logic to it for many of the cases. So we responded to the request for evidence. We were expecting approval quickly after that. They took a long time, beyond processing times, to adjudicate the case. So we contacted Department of State, we contacted USCIS multiple times. Still, they weren't processing on time. So as a member of the American Immigration Lawyers Association, we reached out. Finally, we got the case approved. So another happy ending. Now I want to compare this to this next case where the person was an Egyptian national and they were not a physician. Now for physicians, you have the option of the Conrad 30 waiver. This option, many physicians like this more because of the fact that in a Conrad 30 waiver, you have to work 3 years in the underserved area in H-1B status. So in this situation, you do not have, with the J1 exceptional hardship waiver, you don't have that requirement. And that's why many physicians prefer the hardship waiver over the Conrad 30 waiver, because you can work anywhere you want. You don't have to work in an underserved area, and it gives you that flexibility and freedom. Let's turn to the Egyptian national case that we got approved. In this situation, they have a U.S. citizen child, and we based a large part of the hardship arguments based off of country conditions if they had to return back to Egypt. So here the client hired us because they received Egyptian government funding. that's what made them want to decide to proceed with the exceptional hardship waiver. So we filed the case based off of the qualifying relative here, who was the U.S. citizen child. Another factor of hardship here was that they were expecting a child. Now, another question you may have is, does pregnancy qualify as hardship? Yes, pregnancy does qualify for hardship, but being pregnant is not a qualifying relative. So for instance, if you didn't have a child yet, but your spouse was pregnant, you couldn't file a J1 exceptional hardship waiver unless your spouse was a U.S. citizen or permanent resident. But once you have the child, then you could file. However, it is an extremely good factor of hardship because we like to talk about how difficult it would be to have to, after having a child, move, child care issues, and on and on. So in this situation, we also talked about the inherent dangerous conditions that a U.S. citizen would face if they have to move back to Egypt. And we got this case approved. So every case is different. That's why I invite you to contact our office to learn whether or not your case may qualify for a hardship waiver. And you can also post your comment below. Thank you so much for tuning into this video. Have an amazing day and look forward to having you join another one of my videos soon. Bye.